Hello everyone. Dictation will start in 5 seconds. Start. Subsection within bracket 2 of section 16 of the Arbitration and Conciliation Act provides that a plea that the arbitral tribunal does not have WP within bracket C numbers 6328/2013 and 4886/2013 page 1 of 15 jurisdiction shall be raised not later than the submission of the statement of defense. Subsection within bracket 3 of the aforesaid section provides that a plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. Subsection within bracket 5 of the aforesaid section, which is relevant for the purpose of these petitions, reads as under: the arbitral tribunal shall decide on a plea referred to in subsection within bracket 2 or subsection within bracket 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award. Section 37 of the Act, to the extent it is relevant, provides for an appeal from an order of the arbitral tribunal accepting the plea referred to in subsection within bracket 2 of subsection within bracket 3 of section 16. No appeal, however, is provided in case such a plea is rejected. Section 5 of the Act provides that notwithstanding anything contained in another law for the time being in force in matter contained in another law for the time being in force in matter governed by part 1 of the Act, no judicial authority shall interfere except where so provided in the said part. The following two issues of law arise for consideration in these two petitions, where the arbitral tribunal is mandatorily required to take a decision on the plea referred to in subsection within bracket 3 of the Act before it proceeds further in the matter, or it can decide such a plea at a later stage while making the arbitral award. If the arbitral tribunal decides to go ahead with the arbitral proceedings without taking a decision on such a plea, or if it rejects the said plea, whether such an order of the tribunal can be interfered with in exercise of writ jurisdiction under Article 226/227 of the Constitution. Stanza. The petitioner before this court, in response to the statement of claim and also by filing a separate application under section 16 of the Act, challenged the very initiation of arbitration proceedings on the ground that there was no arbitration agreement between it and respondent number 2.